Welcome to Legal Lines. I'm your host, Glenn Smith. Legal Lines is brought to you by the York County Bar Foundation. So I'd like you to imagine a child who loses both of his parents to an accident, or perhaps a disabled child who turns 18, or even an elderly parent who suffers from Alzheimer's. In each of those scenarios, the courts are often tasked with the difficult choice of determining who is going to care for these individuals. Sometimes the courts are presented with a number of viable options, and well, sometimes they're not. Here to help us better understand guardianships in custody, I have two guests with me first today. So we have Suzanne Griest with us, a local attorney here in York. She's been practicing since 1981, and she's a partner at Griest, Himes, Herald, and Reynosa. She practices primarily in family law, estate, and real estate law, and serves as a hearing officer for dependency, delinquent cases, and a lifelong resident of Northern York County, former president of the York County Bar Foundation and Association, and a charter organizer of York County Children's Advocacy Center. Welcome, Suzanne.
Thank you.
Also with us today is Bryan Tate. Hi, Bryan.
How are you?
Doing well. So Bryan is the sworn Register of Wills and the Clerk of the Orphans Court, which we'll be getting into in just a little bit. And you've been serving in that role since 2020. He's also the co-owner and president of Building Unrestricted LLC, which is a consulting firm focused on building unrestricted assets at community foundations and other nonprofit charities. Bryan previously served 14 years as vice president of York County Community Foundation. He's a native of York County and a graduate of Spring Grove and Temple University, and also served 12 years as chief of staff to former Congressman Todd Platts, who is now Judge Platts. All right, folks, so let's get right into it. So, Bryan, you serve two roles in the county. One is Register of Wills, and the other is Clerk of the Orphans Court. So let's start off with Register of Wills.
That's correct.
What do you do? What is that?
Sure. So the Register of Wills has jurisdiction over the probate of wills and estates in our community. And my office has the opportunity to appoint a personal representative for each estate that comes through our office. In doing so, we issue letters, either testamentary or administration. So letters testamentary are when there is a will. Letters of administration are when there is not a will, and then that personal representative oversees the process of that estate and going through all the steps in that estate. And so I also have the opportunity to serve in a quasi-judicial role when there are issues in that estate, and if someone files objections, I can hold a hearing, swear in those who are testifying, receive information, and then make a decision as to how that estate will be handled going forward. In addition, I serve the role as agent for the Pennsylvania Department of Revenue, where I collect inheritance taxes for the state. So far this year, we've collected nearly $40 million in inheritance taxes that we then send to Harrisburg for the governor and the legislature to spend in the general fund. Since 2000, this office has collected nearly $500 million in inheritance taxes, and again, for the General Assembly and the governor to spend for the needs of our state.
$500 million. That's a lot of money.
That is a lot of money.
Wow.
We can talk further about that on another program, but I certainly like to advocate for ways we can keep those resources here in our own community versus sending them to Harrisburg.
I think that's a great idea.
Yeah.
We'll have you back to talk
Excellent.
about that one.
Sounds good.
So let's talk about the other hat you get to wear.
Sure.
And this strange place called Orphans Court, which one would probably think there's a whole bunch of orphan children running around, but that's not the case.
Yes, well, we no longer have an orphanage in York County, but yes, it's an historical term for a part of the Court of Common Pleas, and traditionally its role was the protector of widows and orphans in our community. So it's always been its own separate court in the Court of Common Pleas. It has its own rules and procedures, and it has developed judicial decisions for centuries. And folks use the clerk of the Orphans Court and come through the Clerk of Orphans Court office to resolve disputes in trusts and estates, for guardianships, like we're going to be talking about here, either for minors or incapacitated persons, also for termination of parental rights, and for adoptions. And the state has also included the issuing of marriage licenses in my office. So it's quite a mix of wonderful as well as sad parts of our community.
Thank you, Bryan.
Sure, absolutely.
So Suzanne, guardianships in custody. I know out on the street they're often used interchangeably with some people, but they're not actually the same thing, are they?
No, they're not. They do overlap. A lot of things overlap. With a guardianship, you're seeking the court's approval to either take care of a child whose both parents are deceased, or you're seeking the court to name someone to take care of a parent who might have Alzheimer's or be incapacitated in some way. Or you can be looking to seek the court to have approval if a child is injured in a car accident, for example, and receives some money. They need to have court approval and a guardian to oversee that money. So that's typically what a guardian is. A custody, of course, is who is taking care of the child. And we usually think of it in the context of a divorce or separation of parents, but that doesn't always mean that. You could be seeking a guardian for someone who is a minor and the mother drops the child off, father's incarcerated, and now no one is there to take care of the child. So you might seek a custody action or a guardianship for that as well.
So most of us today have probably actually heard of a guardianship, but we really didn't know what that was, because over the past year or so, there's been a major storyline in national news involving Britney Spears, right?
Yes.
So everybody had been using the term conservatorship for her in that case, whereas they had, I believe it was the father, and it might have been another individual who was taking care of her money. Mm-hmm. Was that a form of guardianship?
Yes.
Okay.
Yes, conservatorship is kind of interchangeable with a guardian of the estate, or you're taking care of the assets or the finances of the person, whether it's a minor or an adult.
So there are actually two different parts of a guardianship then?
Yes, you can have a guardian of the person, which is taking care of the actual person and their medical needs and making sure that they have food, clothing, things like that, and then of their estate, which is their assets.
Now, one of the terms that you used was incapacitated. Now, that's a legal term, right?
Correct.
So that there's an actual definition for what incapacitated is.
Mm-hmm.
So for someone to be considered incapacitated, what's necessary?
Well, generally, you would need to prove that someone is incapable of making decisions about either their personal care or their finances, or they are unable to communicate those decisions to other people. So you might have a child who was born developmentally delayed or has a significant illness, maybe is nonverbal. When they turn 18, they need someone to make those decisions for them and to take care of them.
And the reason for that is typically if there are parents involved with a disabled child, custody no longer applies once they turn 18?
That's correct. That's correct. Mm-hmm.
Okay. Now, who can be a guardian?
Well, that depends as well. Not an easy answer sometimes. But for example, let's go back to the car accident and the child gets a settlement. In that particular instance, you're looking for someone to manage the child's money, and the court will not appoint a parent to manage the child's money. So it would have to be another responsible adult, or there are agencies out there who serve in a trust relationship. If you're talking about an adult and an incapacitated person, say grandma now has dementia, it could be a family member. Again, it could be another trusted adult, or it could be an agency to take care of it, of the person. And the court will someone will file a petition. Evidence will be presented to establish the incapacity, because that's the first burden you have to cross, is you would have to have medical evidence submitted to establish the incapacity, and then the court has to determine who would be the appropriate person or agency to take care of the affairs.
So let's talk a little bit more about the process. And Bryan, I'm going to come back to you.
Yes.
So as you told us earlier, guardianships fall under your auspices in the office of the clerk of the Orphans Court, right?
That's right.
So I just can't get a guardianship. I actually have to apply with the court to get that,
Correct.
right?
That's right.
So what do I have to do? How
Sure.
do I get this started?
Sure. So the first step is coming to the office of the Clerk of Orphans Court. And my staff is very good at asking questions like, why are you seeking guardianship? What are the circumstances? Because first they want to make sure that that's the appropriate thing for that situation. When they dig a little bit deeper, it might actually be that they're seeking custody, and then they'll refer them to the prothonotari's office. We certainly always recommend that somebody is represented by legal counsel. It can be an arduous process in appearing in court, making sure that you follow all the correct procedures. That's very important. But the first step is the petition for appointment of guardian of a state or person, either for a minor or for an incapacitated person. And my staff will help direct somebody through that process.
Now, one of the things I wanted to point out is you had indicated as Register of Wills where there are contests in that area.
Right.
You're the one who I guess we'll call the trier of fact, whereas you will hear evidence or testimony regarding those issues. Are you the one who oversees or hears the testimony regarding guardianships?
So while I do have that quasi-judicial role in the Register of Wills office and do have hearings in those dispute cases in estates of decedents, I am not the judge in the Orphans Court. There are judges of the Orphans Court. My office is simply the filing office where a petitioner and their attorney would come to get the petition, to start that process, and go through the steps to have the court date called for that process to begin.
So in those instances, we have one of the members of the bench, the county elected judges would hear that particular case.
That's correct. We have two Orphans Court judges in the Orphans Court, and it would be their responsibility to hear those cases.
Now, I'll throw this up for either of you. So I've gone ahead and I've filed a petition, and they've set a court date, and now I have to go and I have to convince the judge that a guardianship is appropriate in this instance. What do I have to do? What do I have to show?
Well, first you have to show the person is incapacitated and and whether that and to what extent they need assistance. So typically you're going to have a medical person, the person's doctor or some treating physician, present evidence or a letter saying that this person is incapacitated and does need help, how they're incapacitated, and what kind of help they need.
Now, with speaking about the type of help, what different areas of help could you be focusing on?
Well, can someone bathe themselves? Can they cook and provide food for themselves? Can they meet their daily needs? Or can they do those things, but they can't manage their money because maybe they have a psychological problem or a mental health illness that prevents them, they blow their money, and so they just need somebody to help them take care of their money. So it could be just a guardian of the estate or just a guardian of the person, or it could be both.
All right. Well, we're going to go ahead and explore that a little bit more after the break. So stay tuned and we'll see you right back. Back to Legal Lines. Again, I'm your host, Glenn Smith. So when we left for our break, we were talking about guardianships. And Suzanne, So we were talking about the ability to get a guardian for the individual or the person, also for the estate or that individual's finances. Let's talk a little bit about a term called plenary. So what is that?
Plenary guardian is a full guardianship, a complete. In other words, the person takes over all aspects of it versus a partial, which means they're only appointed to handle certain limited things.
Does the court have a predisposition as to the type of guardianship it will award?
I would say the predisposition is to grant the least amount of power that they need to for the individual.
And is it as simple to say, if I'm requesting a guardianship, let's start off with the person, that it's an all or nothing scenario, whereas if I get guardianship of the person, I'm making all the decisions?
For the person,
Correct.
true. But there can be a different person there can be a different guardian for the person than for the finances as well. Because you might think of the elderly mother, let's say, and maybe one of her children is better able to take care of the medical decisions for the parent because she's a nurse or whatever. And they have a son that's an accountant, and I know I just was kind of stereotyping it, but in that particular instance, it may make sense to name one child to be the guardian of the person and one child to be the guardian of the estate.
Well, expertise is certainly going to weigh in the court's decision. So that makes a lot of sense, where if you have an expert in your family in one of those areas, or someone who it's very easy for someone to live with, the court certainly wants to hear all perspectives.
And as we mentioned before, it could be a family member. Mm-hmm. It doesn't have to be a family member, and it could be even a professional as well. Is that right?
And the worst scenario is if you have multiple family members who want to be the guardian and they cannot agree. Then it could get contested.
And then it's up to the judge to make a decision.
Correct. And it might not be any family member in that instance.
Once I receive a guardianship, does that remain forever?
Till the person if it's a minor, till the minor turns 18. If it's an adult, yes, until someone seeks to have it changed, or I suppose there are times that people could recover. Maybe you got a guardian because your parent was in a coma, and maybe they come out of the coma and it's no longer necessary. So it could be a situation like that. I will say that if you are a guardian, you have a duty, and Bryan could speak to this a little bit better, about annual reporting of the decisions you make and what you do.
Right.
So in other words, if I become guardian, I just don't get my guardianship and I go away. There's actually some level of oversight.
Yeah, there's regular follow-up. You have to report back to the court on a regular basis so that the court is assured that you're carrying out your duty. This isn't something to be taken lightly. And I think sometimes folks, and that's why we always encourage folks to have legal representation, because they're entering into this process. They are looking to get that court affirmation that they're the right person to play these roles. But then there's a very high level of responsibility with those roles. And the judge would certainly be very quick to call you back in if you're not fulfilling that duty.
Now, one of the unique things about the orphans court themselves is they refer to that as a court of equity versus a court of law. So in other words, the judge in orphans court has a level of discretion in oversight as well as determining who is a guardian that you would not normally have in a normal civil court. Is that accurate?
Yeah, that's accurate. And also, I think it's important to note that if you are named as a guardian, you have what's called a fiduciary obligation. You have a legal obligation to act in the best interests of the incapacitated person. And in York County, we have a guardian mentoring, we have a mentoring program where we have volunteer attorneys who go out and they actually visit the incapacitated persons to ensure that the guardians are doing the job they're supposed to do.
And if that guardian does not, what happens?
Well, any person who doesn't think they're doing their job can file a petition with the court and have a hearing to determine, for the court to investigate whether they are or are not doing their jobs.
And if the guardian was handling the estate, is there the ability to be personally liable?
I suppose if they acted inappropriately, yes.
So
Yes.
misappropriation of funds, not using those monies for the best interest of the individual that they were caring for.
That's correct. Yep.
Okay. Well, we've talked exclusively about guardians up to this point, so we're going to switch gears and we're going to talk a little bit about custody at this point. So, Suzanne, how does custody differ from a guardianship?
I would say the court would prefer parties to file in custody rather than guardianship, except for those areas where you have to file a guardianship. So let's go back to my example of mom drops the child off at grandma's house and says, I'll be back in a week, and then they don't come. And grandma ends up with the child. In that particular instance, it's more appropriate for grandma to file a custody complaint to seek custody of the child.
Who can file for custody?
Oh, that's a good question, too. Anybody who's been in loco parentis, which means has been in the role of a parent with regard to the child. And I would say it's got to be at least a 6-month period of time to get it.
So that could be an aunt, that could be friends of the family. It doesn't necessarily have to be blood relations.
Correct, and there is a separate custody statute that deals with grandparents and whether they have standing. And I think we all know in this time, or the time when we had the significant heroin addictions, there's a lot of grandparents ending up getting custody or having custody of their children until their parents are in recovery.
So that raises a good question. In awarding custody to someone who's not the biological parent, whether it's as a result of a parent being incapacitated or a parent having to go to inpatient rehab or even in prison, does that terminate the parent's rights?
No, absolutely not. Only an adoption could do that.
And with a guardian, similar to a guardianship, how long does that custody remain?
Once you get an order, it remains in effect until the child turns 18. But with custody orders, they're always subject to modification. So as circumstances change in the dynamics, a custody order can be changed if someone petitions and requests that. I did want to say one other thing. Sometimes parents go away. Sometimes they go on a vacation and they don't take their children with them. Or sometimes parents will be in a rehab facility or a hospital and they're not available to make those decisions for their children. So they can give what's called a standby guardianship to whoever's taking care of the child to take care of their medical educational needs while the parent isn't there. But it's a temporary thing.
And the reason I would want to do that is, what's the benefit?
Because let's say the parent's in Florida on vacation, the child falls and breaks their arm at school. Who's going to have the authority to authorize the doctor to treat them at the hospital?
Excellent advice.
So I will tell you I have done these. I have done what are private guardianships sometimes and not gone through the custody court to get a custody order, but they're always temporary. They can always be revoked by the parent. And I will say if the caretaker is looking to put the child on their insurance or anything like that, they've got to have a custody order now. So it's more appropriate to file a custody petition than a private guardianship.
Does the child have any say into who will be their caregiver under a custody action?
The answer is the child does not have the absolute say. The child does not drive the train, but the older the child is, and the more mature the child is, and the more the child can communicate the reasons for why they want a particular person to be their custodian, the court will lend more weight to that. Likewise, in a court guardianship proceeding, when a child's 14, they have the ability to say who they want to be their guardian. The judge doesn't have to follow it, but the judge will give more weight to it once the child is beyond that age.
So let's talk a little bit about what one can do to prevent having to go through a guardianship, or even for custody for that matter. Because one of the things we didn't talk about was, at least pre-COVID, one of the requirements the court had for a guardianship is they often required the individual who was going to be subject of that guardian to be brought into court. And one of the instances that I've seen is where you have somebody from a nursing home and they suffer from Alzheimer's or dementia or something else, and that can be a rather traumatic event for the individual. And it's unfortunately necessary in sometimes for the court to actually interact with that individual. So these are not necessarily pleasant experiences for anybody involved in it. What can I do to try to avoid some of these things? Are there any types of planning or steps I can take, Bryan?
So I'll share that the great commercial that as Register of Wills I'm always out there promoting is that folks should go through estate planning. Everyone should have a will. And what's important about that is you're making the decisions about what's going to happen after your lifetime. So you can include in that, if you have children, you can include who might be the guardian or the caretaker of your children. And then that way, that process doesn't have to happen when you're not around to make those decisions. Similarly, if you're going through that process, why wouldn't you have a living will? Why wouldn't you have a power of attorney for yourself? And then if you are ever in some type of emergency situation where you're unable to make decisions for yourself, you've already named who would be that person to make those decisions for you. And so then your loved ones don't have to go through the court process to have a judge make that decision for you. So it really makes a lot of sense to do all of this stuff on the front end when you can make those decisions versus having to have somebody else make those decisions for you.
Makes perfect sense.
That's an excellent point. It really is, because I have a lot of clients and you get to say who you want to take care of your affairs, because otherwise it opens the door to multiple family members coming in and saying, we want to do it and we have their best interest at heart. And the other big thing I tell my clients is it's a lot cheaper, folks. You can do a will and a power of attorney much cheaper than you can pay me to file a petition, get a doctor to come in and testify, and go through all that trauma that you talked about in a court proceeding.
So how do I do this? How do I get a will? How do I get a power of attorney? How do I get a health directive?
You contact one of our great local attorneys who can help you through that process. And I guess you can reach out to the Bar Association if you need suggestions.
You absolutely can. So you can get a referral from the York County Bar Association. So, well, we've run out of time. Suzanne, Bryan, I thank you so much for being with us today. You've been watching Legal Lines. Legal Lines is brought to you by the York County Bar Foundation. You can learn more about us at the York County Bar Association or the York County Bar Foundation's website. So until next time, thanks for coming.